As it was a court appearance for the state as it was.
May it please you, my lord, I appear for applicants 1, 2, and 3 as previously.
Yes, my lord, I'm still on record as before.
As the court cases, I appear on behalf of 5 of 6 respectively as before.
Yes, Mr.
Your Lordship, the court has requested for the Deputy Commissioner from the correctional facility to be present. He is here, Your Lordship.
Where is he?
They will just call him to come in.
Yes, whilst we are waiting, I'm told there is a request somewhere from the printed media. Am I correct?
I'm not aware of any request.
Yes. Oh, yeah, I see. Yes. It's on condition, it's just office, you don't communicate with you. Yeah, okay. All right. Yes. Is it Commissioner? Or
Yes.
Commissioner?
Armas.
Yes, yes, if you can just quickly. Yes, Commissioner Armas?
Yes.
We had a few challenges, and the challenges that we have had, I'm informed, is with respect to the collection and, of the applicants in this matter, and for them. Is there a possibility that arrangements can be made that by 9:30 they are ready for pickup, and when the people coming to pick them up don't stand and waste time?
Yes,
because what I have been informed is that at times the team that collects them only gets access to them by 10 to 10, and then they have to speed through the streets of Windhoek to get to court, endangering both their lives and the applicants' lives.
Okay, thank you, my lord, but that was not brought to my attention.
Yes.
Yeah, now that is brought to my attention, I work on
At
it.
least 9:30 they must depart from the correctional service facility.
No problem, that will be done. To be arranged.
Okay, thank you.
Okay.
You are released.
Thank you.
Yes, Mr. Soni. I have a court orderly, Mr. Good. Yes. Mr. Kanyengela, you are reminded that you are still under oath. Did you get the affidavits, copies of the affidavits?
Yes, my lord.
You have gone through them?
Yes,
all right.
Lord, when we adjourned yesterday, I had just about completed the case of Mr. Shangala.
Yeah.
and then I was going to start the case of applicants 2 and 3. And of course, the witness hadn't read the affidavits in support, and he's been given an opportunity to do that. Lord, before I deal with the affidavits of applicants 2 and 3, may I finish a small part of the questioning in relation to Mr. Shangala? It won't be long, and I'm aware that I've come to the tail end, my Lord, and I'm aware that a fair amount of time has been taken in the questioning.
They say justice has got no eye for time.
Yes, it's the destination rather than the journey.
Okay.
Mr. Shangala, Mr. Kanyengela, let me ask you this. You remember yesterday when I was asking you whether you knew Mr. Shangala, who is applicant 1? You remember that?
Yes, I remember.
And as I understood your evidence, and you must correct me if I'm wrong, you said that you knew his grandfather.
I say he know his father.
Sorry?
I say I know his father.
Oh, his father.
Yes.
All right. Now, is it not correct that the Shangala family of the first applicant and the Kanyengela family of yours are related by marriage?
I'm not aware of that.
Your father's brother is a Mr. Shapumba Kanyengela?
I don't know such a brother of the name Shapumba. Never.
You know a lady called Monica Mumbaja?
I cannot recall such a person.
Okay, my instructions are that she is married to your father's brother. You dispute that?
I'm disputing it.
Okay. Now, my further instructions are that there was, on account of historical factors we need not go into here, a dispute over a house between your uncle's wife and the Shangala family. You aware of that?
I know that there was such a dispute, but I can still say I'm not aware of that uncle of mine that you are talking about.
Okay. But, and we don't need to go into details. There is a dispute between the two families, the Kanyengela family and the Shangala family,
Not the
about a
Kanyengela
house.
family, as far as I know.
But a member of the Kanyengela family.
If you are referring to a Kanyengela family, what does that really mean? Because I don't understand. Is it extended family?
Okay.
Or
Mr. Kanyengela, I'm just putting instructions to you. I can only take instructions. I am told that your father's brother is married to the great aunt of Mr. Shangala, who is applicant number 1 here. Are you aware of that?
I'm not aware of that.
Okay. Let's just get back to the dispute. You're aware that there is a dispute over a house?
I'm aware of that because it is a village house.
Sorry?
It is at our village.
Yes.
Yes.
And yesterday when I asked you, I understood you to say that the two families lived about 7 kilometers apart. You remember saying that?
I say his father's house, yes.
Well,
From our house.
my instructions are that the distance is about 2 kilometers.
I cannot be.
Sorry?
It cannot be.
It cannot be, okay. I also want to say that the dispute over the house, and you must tell me if you're aware of this, was eventually settled about 2 years ago by the Ombudsman. You're aware of that?
I'm not aware of the settlement.
But it was resolved by the Ombudsman.
I'm not aware of that.
So, in your mind, is the dispute still going on?
I know it was going on, and I don't know where it ended up.
Yes. But you knew at the time you gave evidence and at the time you were doing this investigation that there is a dispute between the Kanyengela family and the Shangala family.
I'm still insisting there was no any dispute within the Kanyengela family and the Shangala.
Okay. The dispute, though, is over a house, and you say it's not a dispute between two families.
Not with my Kanyengela family.
Okay.
As far as I know.
I'm going to put to you that my instructions are that, in fact, you're aware of the dispute. The dispute has created a tension between the families, and that is one of the reasons you have such an antagonistic attitude to Mr. Shangala.
That is false, unfounded allegation.
Yes. Okay. Now, let me get to the case of Mr. Hatukulipi first. And I just want to ask you, you did read his affidavit. I gave you my copy, you remember?
Yes, I read the affidavit.
Yes, you've read his affidavit.
Yes,
Now, I just want to go over the issues, and I want to make this as short as possible. You read Mr. Shangala's affidavit whenever it was.
Yes.
You read Mr. Hatukulipi's affidavit yesterday.
Yes.
You agree that most of the allegations are the same except in respect of their personal circumstances and so on.
That's correct.
They all depend on the fundamental rights, and they all depend on the contention that the investigation by the ACC in respect of money laundering and racketeering is unlawful. You're aware of that?
Yes, I'm aware.
Okay, so I don't need to go through that with you because I've been through Mr. Shangala's affidavit with you. You've responded to it. I take it that your response in regard to what Mr. Hatukulipi says on those matters would be exactly the same, unless you want me to go through everything.
Yes, correct. It will still be the same.
Okay. Then can I ask you to just look at the differences, and if I could ask you to look at Mr. Hatukulipi's affidavit and turn to page 35, paragraph 72.
Yes, I'm there.
Okay, this is the section where paragraph 71. This is the section where he talks about his personal circumstances. Just want to read to you what he says on oath, by the way. I suffer from hereditary hypertension and have been on medication which requires being taken daily and a balanced diet which is not available at the Windhoek Correctional Facility. Now, can I ask you, are you aware that Mr. Hatukulipi suffers from hereditary hypertension and is on medication?
I'm not aware. Okay. I just see it now from the statement.
Yes. Had you read the statement, would you have made inquiries as to whether that allegation is correct?
I did not make any inquiry.
Okay. Now, he says that given those conditions...
From the answer that he gave,
Yes.
I am not sure he understood the question. Maybe repeat the question.
As my Lord pleases. Had you read the affidavit before you came to give evidence, would you have made inquiries to check whether this allegation is correct or not?
My Lord, with regarding to this allegation based on the sicknesses of the applicants, I might say that I really don't have that capacity to investigate what is being alleged. I'm not a medical practitioner. Therefore, although such allegation is being made, it must be taken up with the relevant authority, maybe where they have been detained, so that they can see what arrangement can be done for them. But to say I must investigate their sickness, I'm not having such capacity.
And you don't think it's a human thing to do when somebody says, I am being put in jail against my will, I have a right to apply for bail. One of the factors that I would ask the court to take into account is the state of my health, that when you're opposing bail, that you will not say, well, that allegation is probably correct or that allegation is incorrect. You don't think that that is an approach you should adopt?
I really don't need to investigate such allegations.
Yes.
The applicant before this court, they are applicants, they are not laymen. I have indicated that the applicants, they have committed such offenses for a longer period of time. And as well-educated person, they could know as to what will be the consequences of their corrupt activities. To say that they must be granted bail because of their sickness or because of they are not getting balanced diet to supplement their medication, that's the thing that we are supposed to take into account before they commit such offenses. And I still say that if they are having such problems, arrangement can be done with a correctional facility where they are detained to see what other balance that they can offer, the state can offer for them, all to adapt to the situation as it is. That is my answer.
Now, can I just say, this is now an application where an accused person who is in custody and is applying for bail places information before the court on oath. I'm just going to put to you what the legal position is. For the purposes of the bail application, the court must accept the correctness of this, and if there's merit in what you are saying, that they should have thought about these matters before they allegedly committed their crime, and you seem to be the judge in all these matters. I've never heard you say it is alleged. Now, I'm just saying that I'm going to ask His Lordship at the end to take all of these facts as undisputed facts. And His Lordship will, at the end of the day, attach whatever weight ought to be attached in terms of the legal principles to these undisputed facts. I'm just putting to you that that is the proposition I'm going to make to His Lordship at the end of these proceedings.
Yes, I understand that, my Lord.
Now, in paragraph 72, he says, I have 3 surviving siblings one in the United Kingdom, another resident in Windhoek, and another in Otjiwarongo. Are you aware of that?
Yes, I see it, no?
No. I know you see it there. Are you aware of that? Do you accept that that's correct?
I cannot dispute that.
Then he says, my assets are subjected to a restraint order, and unless I am found not guilty, I will not be able to use my assets freely. That must be correct, isn't
That's
it?
correct.
In terms, yes, okay. And then he says, grave doubts have been cast on my career, on my character. I am not guilty of any crime, and I intend to stand trial. Now he says that on oath. You can't dispute that, can you?
His guilt is still to be proven, yes?
Sorry, just say that again.
I say his guilt is still to be proven.
Yes. Oh, we have finally accepted our position, Mr. Kanyengela, and I say that as a compliment. Right. But he says now, I intend to stand trial. You can't dispute that, can you?
That is a statement that anybody can say.
Yes.
He said he can stand trial.
And anybody can say, but he won't stand trial. You accept that as well?
I am, as an investigator, I said, due to the seriousness of this matter, and due to the experience he just made while in detention, there is a likelihood for him to abscond.
Sorry, just say why you say there's a likelihood for him to abscond. What did he do?
He is aware of the seriousness of the case he is facing.
Of this case?
Yes,
But you know, you've just said his guilt hasn't been proven yet.
that's correct.
Yes. Then in paragraph 73, he says, I have no intention of absconding. I'm a businessman with extensive commercial and farming interests in Namibia. You're not in a position to dispute that, are you?
Yes. A statement like that can be made.
But we've heard that before. All I'm saying is, you can say that I do not accept it, but you can't simply say that a statement like that can be made, especially if it's on oath.
I will still say, although he's having business interest in Namibia, he can still abscond.
Yes. Just like he can still stand his trial.
That's correct.
And I tell you why I say that. I'm going to come to that in a moment. You know, he was like Mr. Shangala in South Africa when the first warrant for Mr. Esso's arrest was executed. And he came back knowing that he is one of the persons against whom a warrant was going to be issued. That is correct, isn't it?
It is correct. He came back.
Then he says, I hold interest in various commercial entities operating in Namibia in various sectors of the economy in addition to being a farmer. Well, you only read that last night. You
Yes,
haven't
I
had a
did,
chance
yes.
to investigate that, have you?
I don't have a chance to investigate, but I know that he's a farmer.
Oh, okay, so that is now true. that he's a farmer?
I say I am aware that he is a farmer.
Yes. And he has other interests?
Yes, in some of the businesses, yes.
Yes. Then he's makes the point I made. When the allegations were brought into the public realm, I was traveling on the continent. I came home when I learned that there were investigations concerning me, and the former Minister of Fisheries and Marine Resources was arrested. When the minister was arrested, I was in South Africa. That's correct, isn't it?
Yes.
Right. Then he says that whilst I have permanent residence in South Africa, and we've been through that it is as a non-South African citizen, he says, my permanent resident identification document and my Namibian passport have been confiscated by the ACC.
Yes.
He says he does own assets in South Africa, but he has no intention of absconding.
That is what he's saying, yes.
Yes. Okay. Then he says at paragraph 75, I will not be able to use my assets unless I am found not guilty. And that's based obviously on the fact that there is a restraint order issued by this court, which order, of course, the applicant, like everybody else, has to accept and obey.
That's correct.
Then he says, I record on oath that I will not interfere with the investigations or with state witnesses. What do you say to that?
As I have already indicated, he have interfered before. And buying out on bail, he can still interfere.
Yes. But if he interfered while he was in jail, he can continue interfering. That's right, isn't it?
He can continue.
Yes. But let me get back to how you arrive at that matter. Remember, as I understand it, in terms of interference, yesterday your evidence was to the following effect, that he had conspired with somebody to deal with some bank accounts or whatever.
Just
or bank cards.
To get cards from
Yes.
our office, yes.
That person was Mr. Jason Iyambo, isn't that so?
That's correct.
Now, Mr. Iyambo's case, and your version, is over, am I right?
The case of Mr. Iyambo is over.
Well, before we go, I know what you want to say. Let's deal with Mr. Iyambo first.
Yes, his case is over.
What was he charged with?
He was... I know that one of the charges was related to the bribery of the ACC office
Yes.
official.
And the other was obstruction of justice, wasn't it?
This case was being handled by another person.
Okay, you're not in a position to dispute it.
No, I did not really see as to which charges.
Yes. Can I ask you, were you present in court when he was convicted?
No, I was not present.
So let me tell you what happened and then tell me whether you have any evidence to dispute it. That when he appeared in court on the charges of bribery and obstruction of justice, he pleaded guilty to obstruction of justice. No evidence was laid on the bribery charges, and he was discharged in terms of Section 174 of the Criminal Procedure Act. Are you in a position to dispute that?
No, I cannot dispute that.
Did you make inquiries before you came and gave evidence yesterday and made such serious allegations against Mr. Hatukulipi?
I did not make any inquiry, but it was a fact that he indeed have sent somebody to bribe an SEC official.
But you know, Mr. Kanyengela, that's why I placed on record that he's been found not guilty. Why do you keep insisting that you determine a person's guilt? That's what courts are for. And surely as a senior member of the ACC, you should know that.
Yes.
Now, I'm saying to you, a court found him not guilty of bribery.
That was just on Iyambo, and the case is not yet finalized in court. The applicant is still facing that case.
No. We are not talking, because your evidence yesterday related to Mr. Iyambo. And I'm saying to you that on the evidence or on what I am putting to you, there is no bribery charge against Mr. Iyambo because he's been found not guilty.
Your Lordship, so far as that is concerned, I think we will try to obtain the record and provide it to the court. But from my recollection, speaking to the prosecutor, those charges were dropped. So I don't think there was a finding of not guilty, but we'll try to obtain the record for the court, Your Lordship.
Lord, I'm surprised at my learned friend's intervention in this. And I say this for two reasons, my Lord. I did indicate it was Section 174, but let's assume I was wrong about that. If a person has pleaded and the charges are dropped, the accused is entitled to his acquittal in terms of the Criminal Procedure Act. My learned friend must know that, my Lord. So, on Mr. Iyambo's record, it would be found not guilty because he's already pleaded to that. And that is exactly what I'm putting to the witness, my Lord.
I think what Mr. Lutubetsi says, I don't know.
Yes.
Whether you didn't put to him that he pleaded. You did not put to, all that you said is he was discharged in terms of 174.
Yes.
Because so whether, I'm not sure whether he pleaded, the trial kicked off.
My Lord,
because he faced a number of
yes.
charges. All that Mr. Lutubetsi is saying is he'll endeavor to obtain the record,
yes,
and place it before court.
I've got no difficulty with that, but it can't interfere with the cross-examination for two reasons, my Lord. The accused in that case pleaded guilty, and I've already put it to the witness, to the charge of obstruction of justice. He was found guilty on that. No evidence was laid in respect of 174, or the case was dropped. It doesn't matter. In terms of the Criminal Procedure Act, with respect, my Lord, that accused, Mr. Iyambo, is not guilty of the crime of bribery. And that's all I'm trying to put to the witness. And again, my Lord, it is to demonstrate to your Lordship, and that's why I flogged that horse, is this witness's approach is, I determine a person's guilt. And I'm merely trying to amplify that to your Lordship through his evidence, that is his mindset. And it is a factor that your Lordship must take into account because it's now on record when determining overall whether bail to applicants 1, 2, and 3 should be granted. That's the relevance of this part of the evidence. Lord, my learned friend has provided a helpful solution. I've put my questions to the witness on this matter. When we get the record, your Lordship will be able to match the cross-examination with the outcome in the court case, and whatever is the result of that would be the acceptable outcome. But I want to make another point, Mr. Kanyengela. See, you've raised in respect of Mr. James Hatupulipi, you've said, but he is a person who bribes people or causes people to bribe ACC officials. That's the basis, the thrust of your opposition on this score. Well, firstly, he is in prison, so we needn't take that into account. But you are trying to show to his lordship the type of person applicant number 2 is. And I'm saying to you that a fair-minded person, and especially a witness who's making such a serious allegation, would know the facts before he comes to court. Would you accept that as a general proposition?
I have already indicated to this court that Mr. James Hatupulipi was the one who sent that Jason Yam. In the sense that he was the only person aware of what was seized from him, and he gave instruction to Jason Yambo to come and try to get those documents from the ACC.
That's what Mr. Yambo says.
Yes.
The state's case was so weak, even on the evidence of my learned friend, it dropped the charges. Or the explanation by my learned friend.
I don't know why the charges were dropped.
But what we do know is you didn't investigate before you repeated those charges when you gave evidence yesterday.
Yes, I did not investigate this.
Then he says at paragraph 77, I record on oath that I will not interfere with the investigations or with state witnesses. Given that the indictment has been served on us, it would appear the investigations have been finalized. Accordingly, there is little or no risk that I will interfere with whatever investigations are still to be done. What do you say about that?
I think with regarding to this saying, I have already given my reason during my evidence in chief. That's why I'm saying that he will still interfere with the witnesses, and I will stick to such evidence.
As I understand it, it's because on your version you have a strong case. Or is there another reason that I'm not seeing based on what you said in your evidence in chief?
I give the reason of him instructing a person to create false documentations as per the information that was found on his device. It was one of my reasons to say that he will interfere.
Any other reason?
Apparently, that is what I can recall of what I have given.
We've been through Mr. Iyambo's evidence, what you say about him. So I'm saying to you, there's no merit in what you say. Finally, can I just come back to Mr. Hatukulupi's affidavit and go to paragraph 78. It says, I've already pointed out that based on the affidavits of the Prosecutor General and Mr. Kanyengela, that's yourself in the restraint application, the state's evidence case is heavily reliant on the evidence of the whistleblower, that's Mr. Stephenson. You've admitted that yesterday, that Mr. Stephenson is a crucial witness.
He's a crucial witness, but in his absence, we can still prove our case.
Yes. Then finally, at paragraph 83, he says, I have indicated above that the trial will be lengthy. 2 proceedings have been joined in one, and this trial, he says, is likely to last a long time. What do you say about that?
What I will say is that the length of the trial, it will depend on how this case is being handled and under which circumstances is the case being handled. But what I can say is that although the 2 cases are having a lot of witnesses, there are few witnesses who might stand in the witness box for a longer period, while others are just witnesses who are confirming the payments made to them or who are confirming the service they have rendered. And they will not really take up much time on the witness box. That can shorten the trial. The people who can take maybe longer, they are less than 20 people, 20 witnesses, who can take longer on the witness box stand. Although we regard the cases to be being with a lot of documentations, I believe, all I can say, this trial can take a shorter period of time.
So it won't take a long time.
I don't see it take a long time.
No, Mr. Kanyengela, you've said what you want to say. I just said, so it won't take a long time. Just answer that question, please.
To my thinking, it might not take a long of time.
Yes. You're not a lawyer, are you?
I'm not a lawyer, yes.
You don't know what a fair trial means because I've indicated to you the manner in which you've done your investigations. So I'm suggesting to you that no reliance can be placed on the factors you give for suggesting that this will be a short trial. I'm saying to you that you've already indicated that there are nearly 50 lever arch files of documents. There are numerous sets of advocates that are involved or legal representatives that are involved. And this trial is likely to last a long time.
That's why I say it depends on how the case is being handled in court and the circumstances.
Yes. And you accept that the accused are entitled to defend themselves as provided for in the Constitution.
Yes, they are entitled.
Yes. So I'm suggesting to you that we can expect when the trial starts, whenever that will be, that the trial will be a long time.
Yes, you can take it like that.
All right. Now, I've dealt with Mr. Hatukulipi's case. I want to now deal with Mr. Imwatulelo's case. Now, at the beginning of this morning's session, I indicated to you that what Mr. Hatukulipi says in his affidavit is quite similar to what Mr. Shangalala says in his affidavit, except for the matters relating to personal circumstances and so on.
That's correct.
Now, you've read Mr. Imwatulelo's affidavit. You accept that the same thinking goes there?
That's correct.
And can we accept that the answers you gave in respect of the first 2/3 of Mr. Shangalala's affidavit up to the point of the personal circumstances would be exactly the same as you've given in regard to Mr. Shangalala's evidence?
It would be the same, yes.
Yes. All right. Then can I ask you, please, to look at page 34 of Mr. Imwatulelo's affidavit. And this is where, at paragraph 70, he sets out his personal circumstances. He says he resides in Windhoek and he was arrested on the 27th of November after he handed himself over to at the Namibian police headquarters. That is correct, isn't it?
That's correct.
And he says that in regard to the firm Otufika Investments, he has 90 employees and they would effectively be seriously prejudiced if he remains in custody. Are you aware that he has 19 employees?
I'm aware that Otufika Investment is having employees, but I cannot confirm the total.
You can't confirm the number,
Yes.
but you can't dispute that it's 19.
Yes, I cannot dispute that.
All right. Then he says in paragraph 71, he's the father of a 4-year-old baby girl who's living with her mother who is unemployed. Are you aware of that?
I'm not aware of the baby or of the mother, of the wife or whatever. But that is what he's saying, yes.
And you accept it for the purposes of this application?
I will accept it.
And he says that his child, his baby girl, is dependent on him and her babysitter for their well-being, and somebody has to pay for that.
Yes, somebody has to pay for that.
He says, in addition, he says he also looks after his 6-year-old nephew, 2 cousins, and aunt. You accept that?
I will accept that, although his version is not supported by anything else, any evidence else, apart from mentioning.
Sorry, just say that again.
I said his statement is not supported by any documentary evidence showing his nephews or cousins or aunts, apart from what he just mentioned in the statement.
And why would he need to put that documentary evidence before this court?
If you want the court to believe that.
He says it on oath. If you want the court to disbelieve it, you should place evidence on oath saying that this is a lie.
I will not say it's a lie.
You can't say it's a lie.
Yes.
He says his arrest continues to wreck him financially and is an emotional strain on those who depend on him. Are you able to dispute that?
I'm not disputing that.
Right. Let's go to paragraph 72. He says, as I've already indicated, I employ a substantial number of people, and although doubts have been cast on my character, I am not guilty of any crime and I intend to stand trial. What's your response to that?
My response is that his guilt is still to be proven. And to stand trial is something, is everybody can say that.
Yes.
People used to make decisions, especially now with the experience he had in prison, knowing the charges he's facing. He can make any decision to decide not to stand trial. I will further say that the applicant is having a concern of the people he have employed, which to me, he made this statement for his selfishness interest, without considering the difficulties the other people are facing, who lose their job because of such corrupt practices. We have fishermen who were employed in the fishing sector.
We are talking, sorry, I don't want to disturb you. We are talking about Mr. Ueitele.
Yes. I know we are talking about him. But he must also think of the pain he caused to the other people.
Yes. And I think you must think about the pain you are causing to people by pronouncing on their guilt.
I did not pronounce them guilty.
You say he's committed a crime. That's
he committed
pronouncing
a crime.
their guilt. Sorry?
He have committed a crime which is still to be proven that yes,
Okay.
the allegation being made against him is true allegations.
Mr. Kanyengela, I don't want to debate this matter with you. We're going to go on and on. I just place on record that I have been unable to count the number of times you have acted as if you are the judge in this matter.
I never act as a judge, my lord.
Now, you say that he would evade justice, but he handed himself over to the police. He could have run away at that time, couldn't he?
Yes, he handed himself because he was not aware of the evidence the state is having against him. Now he is aware. And he was not subjected to prison that night. He now knows the difficulties of being in prison.
Oh, so prison life is difficult.
It should be difficult.
Oh, okay. Okay, so we know now that's a factor that his lordship must take into account.
Prison life is difficult,
Yes.
but to involve in serious charges, serious offenses, we are talking of 317 million, of which these people did benefited.
That's what you say.
Which is a very serious case.
That's what you and Mr. Stefansson say.
And that was our finding during the investigation.
But that's
was
not the
supported.
finding of this court.
It was supported by the evidence or the information we collected.
Yes. Anyway, you've already decided that the accused are guilty, but can I ask you something else? If prison life is difficult and the accused wants to prepare for his trial as he's entitled to do in terms of Article 12 of the Constitution, surely he must be given proper conditions in which to prepare for trial?
My standing in this box, I'm standing in this box with one reason, and that is to oppose the granting of bail to these applicants.
Come what may.
And I just don't want to involve myself in discussion of any bail conditions.
No, I'm not talking about bail conditions. We'll get there at another time.
We'll talk of the conditions.
I'm talking about the grant of bail.
For the accused to have a fair trial, as you are saying, as you are putting it, arrangement can be done with the correctional facility where they are detained. I know their lawyers used to go and consult them. And I did not receive any report with saying that they were denied to have access to their legal representative. So if there is any need for consultation, that can still be arranged.
That's your answer.
Yes.
Now, he says on paragraph 77, I record on oath that I will not interfere with the investigations or state witnesses. You're not in a position to dispute that, are you?
That is what he's saying.
Yes. And he also says at paragraph 83, the trial will be lengthy. We've been through that already.
Yes.
Now, Mr. Kanyengela, can I just say, in conclusion of my questioning you on behalf of applicants 1, 2, and 3, what is clear, and this is a submission I'll make to His Lordship at the end, is you have decided that you will choose what to investigate. That correct?
That is not correct.
You will choose whom to question. That correct?
I did not make such a choice.
Well, you made a choice on whom not to question. Certainly, you didn't question any of the accused, you or anybody from the ACC.
Yes, but the questioning of the accused, the allegations were put to them when they were being charged, formally charged.
No, Mr. Kanyengela, I do not want to go there.
Your Lordship, be given an opportunity to answer. He's answering the question. I want to hear what his answer is.
No, my Lord, my question was in the investigations. Once you've decided to charge, it means effectively the investigation is over. And that's the very point I'm trying to make. And my Lord, if my learned friend wants to ask the witness questions about these matters, he must wait for his turn in re-examination, my Lord. But he can't ask me to allow the witness to answer a question I did not ask.
Maybe we must let him talk, and if it's irrelevant, I'll rule that that's not the answer. But give him an opportunity to.
Please.
I can rule whether he has answered the question or not.
Thank you. Yes, my lord.
Did you understand the question first?
My
Okay,
lord.
Mr. Soni, repeat the question.
See, Mr. Kanyengela, I was making the point, and it started off, and that's why context in law, that's why it is said that context in the law is everything. I started off by saying, you will decide what you investigate. You will decide whom you question in respect of those investigations. You will decide whom you will not question in respect of those investigations. Now, that was my question.
Your Lordship, the question that I have recorded here, the last question is, you didn't question any of the accused. That's when he started giving his answer. This is the question that I have recorded, that you didn't question any of the accused. That was the last.
I asked him to repeat the question, and he has repeated the question.
He has omitted that question now.
Maybe he doesn't want to ask it.
Yes.
Yes, I asked him to repeat the question. He has repeated.
No, my lord, my learned friend is being obstructive. And I say this for this reason, my lord. That's why when I repeated the question, I repeated the sequence in which I had asked the questions. And the questions all related to investigation. My lord, this part of the cross, or what I'm saying now, can't be unrelated to the context. Your Lordship will recall that one of the issues I raised time and again with the witness is why didn't he use his powers in section 21.4? And one of the issues I raised yesterday was that it was a waste of precious state resources. That's the context in which this is being asked. And my learned friend must not adopt the attitude, with respect, my lord, that he can take something out of context and require me to allow the witness to deal with the matter. If the witness is dealing with a question I ask, I'm entitled to say to him, but that's not what I'm asking you. I'm asking you this. And that's exactly what I'm doing. And your Lordship correctly said I should put the question to him again. And I've done it in the context.
Yes, so I say I've given you an opportunity. You have put the question. If you did not repeat exactly what you said, there must be a reason for that.
Indeed, my lord.
Yes.
It's the contextual approach to law.
So I rule that proceed.
As my lord, please. Mr. Kanyengela, can I, and I just want, I've been on my feet in questioning you for 3 full court days, and now this. I just am afraid that you answer questions that are not being asked. And so I'm asking it so that I can put across my point. And it doesn't mean that the prosecutor can't extend those points. But my point to you is, in regard to the investigations, before you made up your mind, you had decided you will not question the accused.
Yes, the accused were not questioned during that time.
Yeah, and I'm making a separate...
Did you hear the question? The question is not whether they were questioned or not questioned. It's what you decided to do. Please listen to the questions.
Yes, I decided not to question them during that time.
And Mr. Kanyengela, I'm going to argue, now that you fairly admitted that at the end of the day, you have a preconceived idea which emerges throughout your evidence that these accused are guilty. There may be other people who are guilty, but they've been told they must make statements, they must give their versions, and you are going to use those versions against the accused. You've chosen who should be charged and who should not be charged. Would that be correct?
Could not be correct, but the applicants, as I wanted to say, they were also given a chance to answer to the allegation or to answer to, but they decided not to say anything.
Yes, Mr. Kanyengela, let us be fair. Let us be fair. The Constitution says every accused person has a right to silence.
That's correct.
Section 21(4) of the ACC says no matter who you are, during the investigations and questioning by the ACC, you must answer questions. But that's prior to being an accused person. So please keep in mind that you are not above the Constitution, nor are your methods beyond the Constitution.
I know that, my lord.
Now, I also want to say to you, Mr. Kanyengela, besides adopting that approach in regard to the investigations, in regard to the bail application, you brought exactly that same approach. I've got to say, I am deeply disturbed that somebody who occupies constitutional power would exercise the power in the manner you have indicated you've exercised your powers. What do you say to that?
I will say, as I have said before, that it was not a must that they have to exercise such power. It is an optional power that they can use.
But even the
Speaking to they, whom do you refer to when you say it's an optional power they have that they can use? Whom are you referring to? Because the question was about you, not about them.
My lord,
No, I just want you to clarify when you say they, who are you referring to?
my lord, I did not hear myself saying they.
Okay. Okay, I heard you saying they. That's why I'm asking you who. Okay, let's start all
I was
over.
referring to
Okay,
myself.
let's start all over again. Mr. Soni, put the question, answer, and listen to yourself now when you're answering.
Mr. Kanyengela, what I was saying is, you decided what powers you will exercise and how you will exercise them. And the proposition I was putting to you is, I'm deeply disturbed at the fact that you can apply your powers or exercise your powers on your version, that you have the right to exercise your powers in the manner you deem fit.
And my answer was that the power that you are referring to in section 21, subsection 4, is optional power that a person can use, that I can use. It is not a must that with every person to be questions, he can be somewhat in terms of that section.
I'm going to, and I don't want to debate this point with you. I've put this to you in a different context. At the end of the day, what emerges is that a decision has been taken, and I've suggested to you, not necessarily by you, but by people who exercise power over you, and you are simply the implementer of those decisions.
If there was such a decision, I'm not aware of such a decision.
And I want to finally say the fact and the manner in which you became the chief investigator and the person to whom you immediately report, namely your wife, is a matter of concern in these circumstances, especially when it is suggested that her appointment was probably unconstitutional.
I don't know what you mean by that. And the appointment of my wife doesn't have anything to do with this case.
Yes. But you report to her.
Yes, I report to her.
Lord, I have no further questions.
Any question in the re-examination?
There's still cross-examination by the others, Your Lordship.
Okay. No.
Unless they want to.
Yeah.
forfeit.
I forgot about it. But before Mr. Kanyengela, I have just one issue that I want you to clarify. That's one. It's clarity. Somewhere during the cross exchange between you and Mr. Soni, you said that Mr. Hatwi-Kulipi, James Hatwi-Kulipi, gave instructions to a person to fabricate documents. Did I hear you correct?
My Lord, it was a message that was retrieved from his device.
No, I'm asking. Let's take it step by step, because in your evidence in chief, I didn't hear that testimony. Even in cross-examination, did I hear you saying that Mr. James Hatwi-Kulipi gave instructions to somebody to fabricate documents?
That's correct, my Lord.
Okay. That didn't come out in examination in chief. In examination in chief, the way I understood is that he asked somebody to go and obtain documents and cards from the ACC. But in the cross-examination, you say he gave instructions for somebody to fabricate documents.
Yes, my Lord, it's two different instances.
Yeah, can you just clarify them for me, the two differences? So that I just, yeah.
There are two differences. One is the information that was retrieved from the Mr. Hatwi-Kulipi's device, asking a person to get invoices from a certain company in Angola, which should indicate as if there was any delivery made to Nangomal Kundavala in Angola. The second instance is when Mr. Iyambo came to bribe an ACC official to get documentations that belongs to Mr. Hatwi-Kulipi.
Okay, that's a clarity I wanted to get. Mr. Soni?
Lord, I've dealt with the Iyambo issue. May I quickly deal with the issue of the Angolan matter, my Lord?
Yes. I just wanted to have that clarity.
And my Lord, I've got to say, I thought they were about the same matter, and I'm pleased Your Lordship has clarified that they are different matters.
Yes. Yeah.
When you were being asked in chief about Mr. Shangala's information being obtained from Mr. Shangala's device, you remember that?
Yes, I remember.
Then you were asked, was that the only device that had been seized? You remember that?
Yes, I remember.
And then your answer was yes, but nothing was found on the other devices. You remember that?
I remember there are two devices. I can say the information that I just mentioned
Can I just interrupt you, Mr. Kanyengela? You know, remember there was a time I asked you here, do you go to church?
Yes, my lord.
What is the color of the jacket you are wearing?
It's black.
The file to your right hand?
It's green.
You see, exactly, you're giving very succinct, straightforward questions, answers to questions. Now the question is, do you remember? Mr. Soni, just please let me not be the cross-examiner.
Yes, as my lord please.
Yes. Can you please ask the question?
Yes.
And please listen to the question.
So I'm just saying, because as His Lordship has indicated, I'm just giving you, before I repeat my question, giving you the context again. You were asked details about what had been retrieved from Mr. Shangalala's device. You remember that?
I remember that.
And you gave evidence about that.
Yes, I did.
And we've dealt with that already.
Yes.
Then you were asked anybody else's devices, and you said yes. Says, was anything else? You remember that? Was anything retrieved from those devices? You remember that?
My lord, with due respect, that device that he's just referring to, of Shanghala, and that device he referring to of the one that was not having information, these are the two devices that were seized from Mr. Shanghala and Mr. Hatuikulipi. The device that was having information on the issue of the Angola, or of the fabrication of the documents, it was a device that was seized from Mr. Hatuikulipi during his arrest.
It was seized during his arrest.
Yes.
Okay. So we now know, and is that not a matter that His Lordship asked you about? Because I think you may have referred to this at some stage in your evidence, and His Lordship asked you, is that before his arrest? Is that the same issue you are talking about?
The information...
No, Mr. Kanyengela, I don't want to stop you. I just don't want us to be at cross purposes. Just listen to the question. If you can't remember, we'll have to find another way. When you were being questioned, at some stage, you made an allegation relating to Mr. Hatuikulipi. And His Lordship asked you, but was that before or after his arrest? Do you remember the question from His Lordship?
I can recall the Lordship asking whether such message was sent before Mr. Hatuikulipi was arrested or after.
Right. Now, this message that you are talking about now, is it the same message that His Lordship was asking about?
It's the same message. Message correct.
So, my Lord, may I then deal with this? So, what we now have is that you've given evidence about material being extracted from a device from Mr. Hatuikulipi, right?
That's correct.
When clarity was sought by His Lordship, your answer was, but that was before his arrest. That's correct, isn't it?
I can still say, I can recall the Lordship asking as to when such message was sent. And I indicated that it was before his arrest.
Before his arrest.
That's correct.
Okay, so all I'm saying is, and we don't have to go back to that, because we know now the message that you are talking about in relation to creating evidence was sent before his arrest.
That's correct.
Yes. That, I'm going to suggest to you, can't be a basis to say, therefore, he should not be granted bail, because he's not done anything in regard to the investigation, because at that stage he'd not been arrested.
But the investigation was still on.
No. We are talking about a different issue, Mr. Kanyengela. We are talking about his interfering with the investigation as an accused person.
Guess I will still stick to that he may interfere with the investigation or with the witnesses, because he did it already.
Before he was arrested.
Before he was arrested and after he was arrested.
When was it after he was arrested?
When he sent somebody to come and collect documentation from ACC.
This is Mr. Yambo.
That's correct.
We've been through that already.
Yes.
Lord, I have no further questions on this issue.
Your Lordship, I think just to clarify one issue, the witness did in fact testify with regard.
It's okay, you can remove your mask
As it
so
plays
that
the
I
court.
can hear you.
As it plays the court. I just want to clarify that the witness in fact testified in evidence in chief regarding that message retrieved from Mr. Hatukulikpi's phone, that the phone was received at the time of his arrest. That evidence is there in chief, Your Lordship.
Yeah, no, he has clarified. Remember, when that piece of evidence was also given, I asked, at what time was the message sent?
Yes.
Was it sent after he was arrested or before he was arrested?
Yes, Your
And the
Lordship.
answer he confirmed now that he said the message was sent before he was arrested.
Yes, Your Lordship.
But the device was confiscated at the time of the arrest. But the message was already sent.
Yes, Your Lordship.
Okay.
As it plays the court.
Yes, Mr. Patel. You still yearning for your coffee?
Yes, my lord.
But it's
I'm
almost
for my
midday.
coffee.
Okay, I'll give you a chance to
My
get
lord,
us.
I've been observing that we normally get 15 minutes, which is not sufficient to go to the coffee shop and back. Maybe if His Lordship can give us 20 minutes,
All right,
and then we can be able to start after that.
yeah. I'll give you 20 minutes to go and get a sip of your coffee.
As it pleases you, my lord.
Got the rice?
But the question,